All right, let's see how we're doing with our. All right, we're back a little earlier. Anybody have any objections to us moving on? Okay, all right, good. Thank you. That's the correct answer. All right. All right, so I think that addresses where we're gonna end up on the information piece. Let's turn to page 6 of the people's submission, Roman 4. But before I do that, I guess, is there, as a trial judge, you always hesitate to ask, is there anything else anyone wants to add? But in all seriousness.
Funny you should ask.
Funny, my friend, Mr. Hollowell.
Yeah, we approached Council Gamble, and our agreement is that the state's going to provide the form and the information that they need. We'll work off that as a template. So.
Great, perfect. Okay, no one indicating else. Mr. Leopold does not have his hand up this time, and so we will now continue. All right, thank you. Roman 4 is discovery. It goes from page 6 to page 87. No, that's an exaggeration. I'm sorry, I shouldn't talk like that. No, it goes page 6 to page 10. All right. This is, I'd like all the lawyers to listen for a minute. Before I was elected to the circuit court bench, I was a trial lawyer for 17 years. And other than one occasion in which Mr. Beam, Tom Beam, not Mike Beam, but Tom Beam and I were local counsel in a patent dispute case. And not because of anything, well, anyway, other than that one case that Mr. Beam and I were counsel on, in 17 years, I never had a motion for discovery, ever. I never had to file one. I never had to respond to one. So when I got to the circuit court, you can imagine my surprise when everybody and their brother, and I mean, I was in a big firm and I had a lot of colleagues who, maybe had a little more discovery issues than I did, but I was so surprised. And I'm always surprised at discovery disputes, because for any of us to have a P number, we have to have gone through undergraduate. We've gotten a doctorate. We've had to pass a bar exam. I mean, we're all smart enough people. We should be able to figure it out. I have no problem whatsoever in having to decide difficult, meritorious discovery issues. I do not think it is an appropriate utilization of taxpayer resources to have to settle silly discovery disputes. And I will tell you what I used to do as a circuit judge. I figured out shortly after I got there, what does it cost the taxpayers of Michigan and of Kent County to have a circuit judge? And at the time, it was about $1,700 per hour. That wasn't my salary, of course, but when you amortize the cost of the building, staff, everything else. And when I would be getting ready for motion hearings on Fridays, if after I was in it, the file for a bit, I'm like, this is frivolous. I started keeping track how many tenths of an hour it took me to get through it. And the non-prevailing party would be assessed however many tenths of an hour, whether it's 1.5 or 0.4 times 1,700. Okay, I'm not saying that because I don't want to be Mr. Mean Guy, but my point is, with the all-stars we have in this case, there should never be any discovery disputes. Really, I don't think. And I'm not saying I'm going to impose sanctions. I don't want to be that judge either. But from my background, I just never could imagine why great lawyers can't get things resolved. So anyway, as far as discovery is concerned. So that is my background. Written discoveries. I'm very curious how the people, attorneys, think 15 interrogatories could possibly be enough. in paragraph 1A, page 7. And 20 requests to admit how in a case with 861 plaintiffs involving a dam that has been in existence since 1923, I think, how is that going to possibly let both sides get the information they need? I don't think we need 1,000 interrogatories, and I don't think we need, but that number to me was like, and I'm curious, how do we do it? How do you get what you need, and how do they get what they need?
Well, I should say, pardon me. We're open, of course, to a different number. Really, my main concern when laying out this provision of the draft CMO, Your Honor, was to try and ensure that the defendants and the plaintiffs are not getting hit with multiple discovery requests about the same body of information from multiple different teams of attorneys. So we don't want the subrogation plaintiffs, the class action plaintiffs, and the mass tort plaintiffs to be asking each of our clients the same basic information. And they don't want the same because we have multiple defendants as well, asking them different. So my main concern here was to lay out a procedure whereby discovery requests are agreed to by all the plaintiffs and they issue, and we do the same on our side. How many of those are? It can be certainly more than 15 or 20. Frankly, we never talked about it. So I'm open to negotiating the number.
Okay. All right. Mr. Juan.
Your Honor, I do not think we should be required to combine, not that we don't get along with the subrogation people or the class people, but that we should be required as a group of 3 different large groups that all have independent complaints. You have to recall, we're all filing our own master complaint for each one of our 3 independent cases. We have different things we need to prove. And so
Like what? What do you have to prove from a liability perspective that is different from subrogation counsel or class action counsel?
there may be some things that are the same.
What is different, Mr. Juan?
Well, the facts that, for instance, the class people need to bring before the court in order to seek certification. Those are things that we frankly are.
As to liability, what is different among the 3 groups?
Nothing.
Okay. So as to liability, why couldn't we have one scorecard of discovery? Why can't the plaintiffs coordinate that?
I suppose we can, Your Honor. We've been working with our own discovery group within our mass tort group, and we've been working towards doing things. We have not been working with those other groups, and so I may find it to be a little unwieldy, but.
No, I get it, but I also get, I want us to go forward with the dispatch that we're able to. So, okay. Thank you, Mr. Juan. Mr. Leopold wanted to say something. Did you have?
And the other thing was the number, we're with the court on the number of questions.
Yeah.
We can't do it for 15 questions.
I'm sorry. No, and I'm not laughing at you. I'm just, 15. I was like, holy cow, how do you get this done with 15? I mean, I wasn't that great at writing interrogatories, but man, you'd have to be Daniel Webster to get it down to 15 interrogatories, either side of the V. But all right, Mr. Leopold, what do you have?
Your Honor, just to add a little bit more flavor to what Mr. Juan was saying, I think both issues and Your Honor's concerns can be addressed, and that surely it is a joint liability, if you will, and the 3 subrogation, class, and the mass property claims should be able to put one document together for liability issues. But also, as was addressed, there are separate and distinct issues that the class may have, that the mass properties may have, subrogations may have, that none of those 3 entities should be per se limited. How much, who knows? That's for Your Honor to decide. But
Right.
You'd also have some ability to ask outside of that one uniform liability.
Oh, sure. No, I wouldn't presume to suggest to the defense the questions they get to ask or who they get to ask it to. And outside of the liability issues, it's not the world is your oyster, but I mean, it's, they're different issues for the plaintiffs. What,
And Your Honor, if I guess I should say, because it sort of dovetails into this issue, just to sort of address, and again, this is how we worked it out with the state in the Flynn case. This dovetails into discovery by way of depositions and all. And, the three plaintiffs, if you will, working cooperatively together on how much time for each party and making sure the witness only has to come one time, things of that sort. So, it does dovetail into the liability issues in total.
Yes. How many?
Your Honor.
Yes.
David, you've been here on behalf of the class. The class has no objection to working with the other two plaintiff groups here. I think you're right, the issue of class certification issues is slightly different than liability, but I think we could work together and share that information prior to serving it on the defendant, just to make sure that there is no potential overlap of liability, that this is not something later on that's going to be asked by one of the other groups or wants to be asked by by one of the other groups. But so it's something, what I'm saying is that's something we can certainly work through to ensure a cohesive working environment, to ensure that the state is not overwhelmed with lots of different requests. And as to the limitations, we also would, I do think those limitations should be in place at this point.
How many interrogatories do you think you need?
At this point, to say with a finite number, I don't have that number for me.
Your Honor, just to kind of, as we're talking, it
For the
brings up
record, this is Mr. Juan.
Tom Juan, I'm sorry, Your Honor. As we're talking, it kind of spurs some thoughts. Perhaps we can have 40 liability interrogatories that are joint, and then allow each of the independent parties to ask 15 additional questions that are not within that group set of questions that discuss liability, that may be more tailored or independently addressed to those specific cases. And so you can have a set. So Mr. Gamble's not answering 3 sets of liability interrogatories, but each group then has an ability beyond that initial set to ask questions that are important to them.
I hesitate to even ask this, but I will. Okay, 40, and how many subparts? Subparts. So 40, and then A through E, just 40. I mean, I remember getting the interrogatories and having, my associates produce them.
So, Your Honor, typically, I think in the court rules, gosh, I think it's the federal court rules for sure, count subparts as an independent
Okay.
interrogatory.
So do the state rules now. That
I
You
think
good with
so.
that?
It's just the way we ask the questions. I
I'll
mean,
take it as a yes. Okay, good.
Your Honor, David Dubin, I would join in with Mr.
Yeah.
Juan's recommendation.
What do you think? 40 main ones on liability and 15 additional per group of, so, obviously that's 45 more, then that's a total of 85 interrogatories.
That's fine, Your Honor.
Okay, good. And sauce for the goose, sauce for the gander. So you get to ask that many as well. Okay, excellent. Sorry. Had a very interesting case this morning and still thinking about case call issues, and anyway, so it's 3:00 and I'm not running out of steam, but I need to concentrate a little bit more. So excuse me while I read some of these paragraphs. Okay, yeah, we're down to request. What about requests for admissions? I don't think those need to be as numerous as the interrogatories, but.
Your Honor, again, Tom Juan on behalf of on the plaintiff side, we'd be happy with 20 requests for admissions as long as each one of the groups gets another 5. just like with the interrogatories.
Sounds good to me. That's
No
all right.
objection
Is that okay
from the
with you,
state.
Dave?
20 and 5. Anybody?
Dave Dubin here on behalf of the class. We agree with that.
Okay. Fowler to be. Okay. Subrogation council says yes. Okay, good. Third party discovery. All right. Let me take a timeout for a minute here. How many of the lawyers in the courtroom or on the internet want to have the chance to try to draft this thing yourself and get it to me by Wednesday of next week?
We're happy to do that, Your Honor.
Okay.
What day?
So
If you really can get it done, I'm not married to Wednesday.
you're talking about this, the draft CMO we're working through, Your Honor, get it to you. I mean, this is our form that we used. you
Right.
know,
No, but my
we're
point is,
fine.
we can go through this thing line by line, or I can give you my general philosophical
Oh, I
observations
see.
of the history of the universe and discovery. And then you all can do what great lawyers do, and you come up with something everybody can live with. But if that's not possible because of schedules, because of vacations planned, then let's keep plowing through it. You know?
Your Honor, I actually think that we are fairly close on a variety of topics.
I think so too.
I think that we really haven't taken the time to meet and confer about these granular details. And so I think that we could probably reach a resolution on, like, for example, depositions, how third-party discovery is going to work, these different
Yeah.
pages. I think where the parties would benefit, though, is maybe the court kind of alluded to this at the beginning of the status conference about how much time discovery should
Yep,
take.
yep.
I mean, that,
Good.
and then facilitative mediation, how that should
Your
work.
favorite topic. I know you
Yeah.
and your co-counsel. So that's really good. We're
So,
going to talk about that.
So I think if the
Okay.
court, I mean, correct me.
Good.
if I'm
That
wrong,
helps
but-
me very much. Okay. Mr. Howell?
Yeah, thank you, Your Honor. Yeah, for sure, we could work together to have that to this court a week from today or.
Right.
beyond.
Okay.
And then, and work through as brother counsel has indicated. I think the only thing I guess we would flag, I'll defer to the head of our discovery group on this. It was just there was one mention in one of the documents about a 13-hour limit for.
Oh, yeah, no,
Depositions. I
Mr.
just-
Howell, I'm so concerned that
It's just a
you
precedent.
already talked about it right when you started about bifurcation, and you talked about length, because I think I need to have my chamber swept for bugs, because I definitely want to talk about that. 12-hour depositions. The Lord created the world in 7 days. I mean, this is
Your Honor,
12 hours.
Your Honor, the reason I propose that is just because under the court rules, each of these folks could depose people over and over and over again. So
No,
I said,
I-
look, if
I
we're just
get-
doing this
no.
once, if we wanted
Oh,
less
my gosh.
time, I'm fine with that. I
No.
mean,
So here's the thing. Okay. Back to what I said before we took our break. You all know 90% of what you know and what you're going to ever know. Spending 12 hours with a representative of Eagle after you've already had the opportunity to review all of the documents, all of the emails, all of the third-party available resources and intelligence and information, 12 hours just seems astounding. It equally sounds astounding that you would need 12 hours or 6 hours to depose the plaintiff's experts or the plaintiffs. It just, like I said, well, let me see. What was it in, the world's first dam was the Jawa Dam. It was built in 3000 BC. I mean, guys, this is an important, I get it. If I were one of the riparian property owners, I mean, your heart and soul, especially if it's a generational home, is in this. I understand it. I get that. And it's important for the agency. And it's important for the plaintiffs. But mankind has been building these things for 5,000 years. We don't have to spend 12 hours asking somebody about some of these things. Yeah, I don't think, but I'm,
So,
the one thing, you're not gonna be boring a jury. So you'll just, I'll be the one that has to listen. So, but and it's not boring, and I don't mean to be disrespectful to anybody, but
Your Honor, the main concern from the state's perspective is that witnesses get deposed once. I don't think there's pushback for the plaintiffs on that. So if we want to decrease the amount of time available, that's fine with me as long as it's split
okay,
equally.
all right. Mr. Juan, and then Mr. Leopold.
I want to tell you, the court, that I agree with you that 12-hour depositions are really boring. Okay. There's no disagreement from me at all. I think it's more appropriate to have a shorter period of time. The one concern I have about the way the order is structured is they've structured it so each side gets half of the time with the
Right.
witness. If it's an Eagle employee that they have access to and we're deposing that person, I don't expect to cut off at the half point for that person.
But here's the rub on that. When we get to the C10 stage, if you've produced your Eagle employee, you're the attorney for the state, the government or the plaintiffs get to ask 6 hours. Let's say I pick 6 hours as the cap. You ask questions for 5.5 hours, but there's stuff that they want to rehabilitate. Are they going to have enough time?
Yeah.
Because as we all know, if you say it at a deposition under oath for C10 purposes, you cannot then clarify it with an affidavit to create a question of fact. So I think it'll cut both ways for the plaintiff too. I don't disagree that 50-50 may not be necessary. I don't know.
I'm with you on that, Judge, but I think with a witness who is their employee, or for instance, if they're with our expert, they should have the lion's share of the time with our expert. We should have the lion's share of the time with their employee.
Okay. All right. Can you live with 75-25?
Sure.
Can you live with 75-25?
What's the total number that you want, Your Honor?
What do you think is the right number?
Well, the court rules are 7 hours, but that's assuming that all the parties get to take a turn at 7 hours each. I think that's way too much. I'm not suggesting that, but
what would you suggest? You counsel, know this case better than I do.
I actually think this is one of the topics the parties can probably resolve
I
through
would think so.
discussion.
Okay.
And so I don't think we need to get it resolved
If you
right
can't,
here.
okay, just then again, like we talked about, is my beloved wife at the end of the readings, here ends the reading. I mean, as I said in my case management order, my trial scheduling order, if this is one of those few things you can't agree on, just you give a joint CMO of all the stuff, and then you got a separate document or separate table and say, we don't agree on this. We don't agree on the amount of time. We don't agree on the percentage. I think 75-25, in my experience of taking depositions in private practice and overseeing circuit court trials, I think that makes sense. I mean, if it's your witness, you don't need 50%. So I'm good with that. Try to work it out. If you can't work it out, I'll fix that one for you.
Judge, I'm looking at the order here, and
What
other
page?
than the whole thing, actually, and I'm looking at page 12 of the order that covers status conferences, which is your bailiwick. But
Thanks.
I'm happy to sit down with Mr. Gamble by Zoom next week and work our way through the discovery
Good.
issues on this.
No,
And
great.
so you don't have to, the court doesn't have to spend its time on this. I'm happy to meet and confer and go over with Zoom, and I'm sure we can come up with solutions to almost all these things, I think.
Okay. A couple things you're not going to be able to come up with is whether or not I'm going to require facilitation or settlement discussions. And when discovery cutoff is going to be, and we're going to have status conferences. Okay. So let's move on first to when the court is scheduling status conferences. We're going to have a status conference on the following dates: May 14th, 2024 at 10:00 a.m. The first 30 minutes, it'll be here in Grand Rapids, each of these conferences. On every status conference day, the first 30 minutes will be in camera. Any lawyer who is present is free to attend. We are not doing in-camera conferences. Those who are attending by Zoom, I am not going to make available for in-camera. I just can't control the environment enough, and I apologize, and I am not suggesting anything inappropriate by any lawyer at all. Not anybody in this case. But if you want to be at the in-camera conference, you'll be here. I will bring coffee. I don't know if I will bring bagels. It will depend on how many people come. But in all likelihood, where you are sitting now, we will probably be, there's an elevator bank to each of your left. We'll meet at 5 or 10 minutes before the hour. You'll go up to the 3rd floor, and then we'll go into a conference room. If there are this many lawyers, 10, there are 9 lawyers. If 9 lawyers are present, we'll probably do it in my chambers. It's not big enough to do it with any more. Okay. So in all likelihood, we're going to be in the 3rd floor, but you'll need a Court of Appeals staff member like Michael or me or one of my team or Dan to let you through it's a limited access space. After 30 minutes or less of in camera, we will then have a status conference scheduled for 90 minutes, and it doesn't have to last that long. Okay, so that's the first one. The next one is Tuesday, August 13th, 2024, Tuesday, November 12th, 2024, Tuesday, November 11th, 2025. Those are the dates we're setting now for status conferences. Sure. February 11th, 2025. Yes. Yep. All at 10 a.m. And anybody can attend by Zoom, but like I said, if we do a conference, if we're doing in chambers, we're not doing Zoom. That's going to be a face-to-face discussions, not by Zoom. All right. Should we be appointing either a special master or a discovery master?
Your Honor, Melvin Hollowell on behalf of Master of Plaintiffs. We believe very strongly that we should. So the first question was as it relates to facilitation or mediation.
No, I didn't ask that yet.
Okay. So the question was asked.
Special master, discovery master.
I defer to my.
I'm happy with whatever the court wants to do with that, Your Honor.
All right.
I actually don't think it'll be necessary. I think the court can wait and see if there's disputes that really come up. I
Okay.
frankly don't anticipate significant disputes that a special master would be needed for in
All
discovery.
right. I'm comfortable with that, and I don't disagree. I will tell you, before 1 o'clock today, I thought it was going to be necessary. I am not nearly so convinced that it's going to be necessary. So that means I'm very impressed with everything I've seen so far from both sides of the case. And Ms. Almenrod.
I had my hand up earlier when we were talking about the depth time, and I guess I didn't remove it down. I apologize.
I apologize for not seeing it. Like I said, I need one of my 30-year-old kids. So once we've been here long enough, you don't need any more tales of Redfordisms. Okay. I understand. Moving on to facilitation / mediation. I understand with crystal clarity the position of the state. I am going to require it because I think this is a case that is appropriate for it. I don't think there is any currency to having it before July 31st because that's when the fact exchange of what are my damages is going to have to be exchanged by based on our discussions earlier. But I also do not think we have to wait until discovery is completed. I think there are real advantages for both sides to see if a central ground can be met. I understand that people believe that they have a very strong case on liability, and we'll learn whether that's a meritorious position or not as the months go forward. But I'm going to order facilitation. And what I would like you to do in your discussions as you're going through the discovery, the CMO, what model do you want to use? Do you want to use, we appoint one person, we appoint a couple people? I mean, theoretically, we could have a settlement conference with one of my colleagues on the court, although two are, I would like you to tell me what you think. And then if that's one of those ones you can't agree on, or the state says, we don't agree with facilitation. However, if we're going to do it, we think it should be, model A, and we're willing to do it anytime after November 1st, or we're willing to do it. We don't think we can do it until after discovery's done. And then I'll decide when it's going to take place. In the past, if parties have not agreed to a facilitator, I have given them the chance, they can each submit to the court one name, and then or two names or three names, we decide on a number, and then I decide unilaterally without a right of appeal or review. And you basically, if you can't agree, you waive it. There are a lot of great facilitators in Michigan. Every person in this courtroom right now knows who they are. They're fantastic on both sides of issues. I could give you recommendations, but you don't need them. So you all need to decide if the state's going to agree, which I don't think you're going to, and I respect that. But even if you don't agree, you get to be part of who we're going to pick, how we're going to do it. Okay? Understand? All right. Any questions from any plaintiffs?
Your Honor, you're talking about the identity of the facilitator or
I'm
the
talking about
timing of it?
how, who, what, where, and when.
Okay,
You know,
because we're fine with getting together with them on who we choose. We just haven't talked about the date, and I didn't.
right, and I guess here in my mind, a date, sometime in 2023 is when you should be doing it. Okay, 2024. Well, okay, all right. Now you. Sorry, 2024. I think you should do it this year. Discovery is going to be completed in January of 2025. Okay. I would love to try this case in May of next year. I do not know if that's possible, but in a perfect world, May 12th, 2025 would be the beginning of the trial. Okay. You don't have to put that in your CMO, but I'm telling you that because when I'm thinking about this case, claims that are at issue and how long they've been at issue, I would really like to get this case done. And I'll be perfectly blunt also, my appointment to the Court of Claims is a 2-year appointment until May 5th. My expectation is if this case is not completed, I will ask the Chief Judge of the Court of Claims, the Court of Appeals, and through them, the Chief Justice, to be able to stay and finish this case. I do not want to pass this to another judge, not because it's a bad thing, but you all have had enough judicial officers. Whether I'm the worst judge on our court or I'm not the worst judge on our court, we need to get this done, and it's a lot easier if, in my experience, if it's the same judge that's been presiding over the rest of it. That's sort of my view, and I'm pretty sure if I said to the Chief Judge of the Court of Claims and Chief Judge of the Court of Appeals, I want to stay on just to finish this case. Oh, darn, no, Jim, you can't. I don't think anybody is going to give me any resistance on that. So there's that.
Your Honor?
Yes, Mr. Leopold, I apologize.
Leopold?
I got to look at the screen more often.
No problem, Your Honor. Just one clarification for purposes of our discussion, just so we know the landscape. By Your Honor's earlier comment, is the court open if the parties agree to use a facilitator that is outside the state of Michigan?
Anybody object?
And I only raise that because, for example, although in the Flint case, we had several facilitators at different times, some have been more recent and it has been quite successful. So although he does not live in Michigan,
My requirement is that they be someone. No, it doesn't. I have no geographical limitation, but if the people or any plaintiff objects, I'll certainly look at it,
Sure.
and say, Judge, I think I hope this goes without saying. If we have some person who's proposed but has been disbarred, or their license has been revoked or they've been decertified as a tenured professor in their school of business for some ethical issue, yeah, I might have some problems with somebody like that. But I can't imagine the superstar lawyers that I have in this case on both sides of the V would select such an individual. So I am not. I think there are a lot of great facilitators in Michigan. I think there are a lot of great facilitators and mediators throughout the entire country. So
thank you.
I'm good with what the parties think is in the best interest of moving towards resolution. And maybe it's even just narrowing issues. I don't know. Mr. Juan.
Your Honor, this is Tom Juan again. In terms of the timing, anytime we're faced with a defendant who at the beginning of litigation says we have a great liability case, it usually takes a while through discovery to help flesh out the facts that might help re-educate them.
Right.
And so I would hesitate to ask the court to schedule something this summer. I would like the deadline to be closer to the end of the year, closer to the end of discovery.
Okay. I thank you, Mr. Juan, for those comments. I do not think there should be, I don't think it's realistic to try to do any type of facilitation or mediation before the end of the summer. I think that's unrealistic because I don't think either set of parties are going to know enough about the case as far as the actual substantive claims by the plaintiff and the locking in, if you will, of the theories of liability that the plaintiff wishes to interpose to seek a judgment in their favor. I think this has got to, there's a process. And I in my mind's eye, Mr. Juan, sometime between October 1st and January 15th, sounds like, gosh, we could get the parties together. By that time, I think there's going to be a good, rhythm going of discovery between the lawyers. I think there's going to be a good rhythm going between who's sort of taking the lead on this aspect for plaintiffs, who's taking the lead on this aspect, who's taking the lead on others. So I think it's just going to take some time. I know this case has been pending a long time, but there hasn't been, there's been an answer filed, so, even though it's 4 years, there's a lot to do. So I don't disagree with you, Mr. Juan. Yes.
So the parties are going to meet and work through all these different dates and get back to the court. But did the court put an end date on when you want discovery to be done?
Not yet.
Oh, I
But soon.
apologize. I didn't mean to jump. And then, but the other issue I wanted to raise is when will it begin? Because traditionally the initial disclosures are what start discovery after the pleadings are in place. So I understand that the fact sheets here are not going to,
Right.
I understand that, but we should wait till the pleadings are in place, I would think, before we have discovery begin.
Okay,
And so
I understand your position. Let's Mr. Gamble, if you could turn to page 4 of your proposed CMO. In the first block, it says replies if demanded by defendants. What do you mean by that?
So a reply is a pleading that the plaintiff has to file if the defendants ask for it.
Okay, a reply to what?
To the answer.
All right, well, you learn something new every day, I guess. So 38 years of lawyering, I guess I haven't seen that. Do you do that on a frequent basis in your litigation?
We've done it before, yes.
Okay.
And part of the reason it helps is because it helps isolate what the true factual disputes are. So the plaintiffs have a story they're telling, we're denying it, and we say, here's what really happened, and then demand a reply, and they have to say yes or no. So a lot of the facts are pretty straightforward. I don't think there's a lot of dispute about it.
Right.
They can be ironed out with the pleadings. So in any event, the court rules, yes, they do contemplate replies to answers.
Oh, okay, all right, fine. Thank you. Mr. Hollowell.
Yes,
And then-
Your Honor. We would object to that. We just think that's just a way.
Well, if they're allowed to ask it,
Yeah.
right, under the court rules. I just have, like I said,
We just think it's a waste of time.
I've been doing this. I've never seen one. And I mean, I was at a pretty litigious firm. I don't think I've ever seen one. I wish I would have had that in my wheelhouse when I was at Plunkett County. Mr. Juan.
We get those. You know what we do?
Did-
We put paragraph 1 through 50 plaintiff objects and disagrees with defendant's position.
Okay.
So nothing really comes of that
Right,
in my
right.
experience.
Interesting. And I'm not, you get to do whatever the court rules allow, counsel, so, but as far as scheduling deadlines and that's what.
We'd like to get moving with discovery.
No,
as soon
me
as we
too,
can
but
with-
do you disagree that we should have the complaints filed and the answers filed?
I disagree to this extent, Judge,
Why?
because the complaints that we've already filed are very specific. And most of the complaints on behalf of the plaintiffs in this case are very similar. And
I
the
agree.
first couple that started out ended up being repeated throughout the various cases that were filed. The state knows what we're claiming in this case. They know what we're claiming. We know what their answer is. We believe we know what their answer is going to be. I don't think that if we wait any longer than 2 or 3, we can get going with discovery in 2 to 3 weeks. And it's not like they don't know what's coming because we've filed all these complaints. It's my belief that the master complaint is going to be essentially a compilation of the prior complaints and put together. It's going to be the same thing.
Right.
And so I'd like to get moving on discovery.
Your Honor.
Final thoughts.
I'm not suggesting we wait. And so looking at this block, I'm not suggesting we wait until replies are filed if we end up demanding them.
Right.
But I do think that the pleadings, which are the foundation of the litigation, should be in place. We should at least wait until their answers are filed and then we can start discovery. I mean,
Okay. Let's see if we can, I understand your position. I think both have merit. The dates that are indicated at page 4 are going to be the pleading deadlines, okay? Discovery can be noticed. So parties can begin to submit discovery and discovery to take place on April 29th, meaning you send out your notices for your deps or your answers to interrogatories or whatever the case might be. Satisfactory or no?
You're indicating that the written discovery can't go out till April 29th?
No, you can send it out, but it's not due until at least the 29th.
So if it's a 28-day return, if we file them by April 1st and they're doing the 29th, then that's within keeping within the court's order. Okay.
we can live with that, Your Honor.
Perfect.
Thank you.
As they say on Star Trek, which you're far too young to remember, but they used to say, make it so, number one. So, all right. Okay. Juan and I are not too old, nor is a couple of other folks. All right. I'm looking for any hands on the internet and the screen. I don't see any. All right. one of the submissions to the court had a very comprehensive system of exactly how discovery and depositions were going to be done. And I thank whoever the counsel was who provided that to the court. At this juncture, we are not going to be issuing an order of that level of granularity and specificity. If, as we move forward, the things become less productive and more acrimonious, then I will be happy to revisit that issue upon the filing of a motion by any party. But as I read through the class plaintiffs' proposed first case management order, it was very helpful on many things. But as far as the details of the exact steps of the court reporter and the highly confidential and all this stuff, I just don't, it doesn't strike me as we need to do that. We may, and I'm happy to reevaluate. So it's a denial of that request without prejudice. As far as the amendment to pleading dates, we've given that. The following dates also are going to work on the dates on experts and witnesses. If you can't figure it out, do the thing I did in the my trial scheduling order. Just tell me what you can't agree on, and I'll decide. I will say that page 10 of the people's submission in the class discovery closure of October 2025, that is not in the realm of something that I'm thinking about. Discovery is going to be completed on January 31st, 2025. January 31st, 2025. My suggestion is mediation before that, but it's a suggestion, it's not an order. I want to ask the people, if let's assume there's a C-10 filed by one side or the other. Whatever the decision is, do you believe that the people would have an automatic right of an interlocutory review?
I'm not sure. I don't think on a C-10 we necessarily would.
I don't think you would either, but it doesn't, I mean, that's something we're not going to have to worry about for close to a year, but
Okay.
I wouldn't think so either. The only reason I asked, I just adjourned a trial with one of your colleagues that I denied C-10 on. And then my law clerk said, Judge, no, you have to adjourn the trial. You're not allowed to go forward. Okay, fine. So anyway, so the reason I just bring that up is the idea of, I sure like May 12th, 2025. That just sounds like a great day to start a 3-week trial. So for planning purposes, if I were a trial lawyer working for the state on this case or the plaintiffs on this case, I would be thinking about that as a day that we might have the opportunity to spend time together. So,
Your Honor, one other just clarification, because it's come up in other cases. Discovery ends on January 31st. Does that mean requests need to be submitted far enough in advance of that deadline?
oh, that's a wonderful question. Yeah. Thank you. Yeah. So council's question, okay, if discovery ends on 1/31, does that mean everything has to be done by then? And the answer is yes. So if it's a 28-day report or response, it's allowed under the court rules. For it to be timely, you'd have to submit it by at the latest January 3rd. January 3rd, 2025 is a Friday. Like I said before, though, you all know what the facts of this are. You know where you want to show liability if you're the plaintiff. You know where you want to show no liability if you're the defense. So let's get her going and get it done. So thank you for that request. Ms. Almanrod?
You had earlier said that the amendment time was dealt with, and I don't see anything for a time to amend pleadings in here, so maybe I misunderstood.
I ordered that the 3 pleadings that are going to be filed is a class action complaint, a mass tort complaint, and a subrogation complaint, and that'll be filed by March 22nd, 2024. And then the answer will be filed by April 26, 2024.
Okay, so as I understand it now, then you didn't intend to add another amendment date. I just wanted to make sure I didn't miss that.
I do not intend to add another amended because I think the outstanding lawyers that are in these cases will be able to get this thing framed the way they want to try it. I mean, obviously, if a party seeks to amend, then the court rules and the case law of the state of Michigan indicates what it indicates, and we'll address that at a later time, but that would be by motion.
And I just want to address the C10 question that you asked. I don't believe that they have an automatic right of appeal on a C10.
Yep. Thank you. And if I counsel, okay, let me just, and I don't mean to be rude. If I seek an answer or counsel from a lawyer, I will ask. And I didn't ask you that, Ms. Allman, but it's always nice to know another person's position. But thank you. I didn't require it. And, but thank you. Anything else, ma'am?
Nothing more.
Okay, Mr. Leopold.
Your Honor, just as it seems like we're close to wrapping up, I just wanted to ask Mr. Gamble if I know everybody in person there wants to get home on a Friday afternoon, but
Right.
either over the weekend or I know Monday's also a holiday, but we're on a short time frame to get something back to Your Honor. So if you could reach out maybe and I can coordinate the plaintiff side, we can set up a time. I don't know if they're working on Monday, but probably not because of the holiday, maybe Tuesday sometime so we can finalize this.
Okay, understand. Mr. Campbell?
The court mentioned that if.
Because you're going to be working it,
Uh-huh.
all right, I'm going to give you till Friday at noon.
Okay.
Okay, so I'd like something to the court by Friday at noon, please. And the other thing I would ask is if you figure out collectively, like Tuesday or Wednesday, we're not going to be able to agree on this, let me know, and then I'll take care of it. Okay. But as of right now, it sounds like you're going to be able to get it done. Let's do it. Friday at noon is fine. Like I said, I've already told you what my schedule is for the next, till April 1st anyway. Yeah, okay. Yes, Ms. Almanrod?
I'm not raising my hand.
Oh, I'm sorry. Your hand's, okay, sorry. Okay. All right. Let me check my notes real quick, please. Solomon Ron, I apologize. I was very short with you and that was discourteous and that was not appropriate, and please accept my apology. I was rude and that does not reflect well on the judiciary, and please accept my apologies.
Oh, thank you, but that, of course, not necessary.
Well, yes, it was, because I shouldn't have said that. And I do appreciate counsel, and I appreciate counsel who want to make sure I get my job done right. And that's all a very good lawyer is doing. And I treated you badly, and I'm sorry for that. Okay, let me take a quick look at my notes. All right. And let me ask Mr. D'Angelo, anything else, Mr. D'Angelo? All right. You okay? All right. The court reporter and the research attorney both say we're good to go. Does anyone on behalf of the plaintiffs, or I'm sorry, on behalf of the state, anything further from you, the council? All right, thank you. For the first, to the individuals who are in the video, attending by video, does anyone else have anything they wish to indicate? Or, and I should have asked this of the attorneys for the people, do you have any objections or correction, any objections you want to interpose to anything I've done, how I've done it, or any other difficulties with the manner in which the court has conducted the hearing today? All right, thank you. All right, for the attorneys who are on by Zoom, anything else anyone would like to add? Or if anyone wishes to place any objections or positions that they wish to put on the record, you may do so at this time.
Mr. Leopold, thank you for allowing us to attend by Zoom, Your Honor.
You're welcome. Yes, everybody's welcome. Thank you. All right, to our 2, 4, 6, 7, to the Magnificent Seven who are in the courtroom. That was a very popular movie when I was a child. To the 7 lawyers who are in the courtroom, our class plaintiffs, mass tort plaintiffs, subrogation plaintiffs, any other things you wish to memorialize or any objections to anything that's taken place thus far?
Just to thank you for grinding through this, Judge. Appreciate it on a Friday afternoon.
Thank you.
Thank you very much. Very helpful.
Thank you.
All right, great. And most importantly, to our subrogation dad-to-be, best of luck, every blessing for you and your family. And we look forward to being spoiled with lovely photographs of your newborn child at our next status conference. I'll send them of my granddaughters. So, all right, if nothing else to bring before the court, thank you very much for your help today. I'm so grateful to be able to work with you. Thank you. The court is in recess. Thank you.